an IP talk. And most of the ones I do, I guess, are more the PhD student postdoc end, where people have been in academia for quite a while and they've got a bit fed up with it and are looking for a way out. So I'm quite pleased to be speaking to you a bit earlier on in your career. So hopefully, I don't know. My aim is to enthuse you that your career is your career and you need to take ownership of it, which is something I didn't do. I just kind of wandered aimlessly around, but that's also fine because you always end up in the right place. And on the IP side, I guess a lot of you might stay in research and things. I think there's a few key bits about IP that I want you to understand to go through your journey. So first, I was going to talk a bit about me and my background. So I did my degree at the University of Nottingham. I did biochemistry and genetics. And then I stayed on to do a PhD in genetics. And my PhD was, this was back in 2000. So it wasn't called synthetic biology then, but I was trying to make an artificial yeast chromosome. And I was also using phage integrases in yeast for the first time. So trying to make tools basically to engineer yeast. So I did my PhD. After my PhD, I still didn't know what I wanted to do. I went and worked at Sheffield University for it was only about 6 months, and it was a research assistant post, but it really was a bit like a PA. So I was working with a particular professor and just helping him do his stuff. So it wasn't a science role. And I realized then I definitely wanted to stay in science. I didn't like being on the side, watching everybody else in the lab doing the science and me just kind of supporting that. That wasn't what I wanted to do then. So I applied for a load of postdocs. I didn't have any particular focus in mind. And one thing I just want to say here, actually, which I meant to say earlier, and perhaps you're all a lot more clued up than me, but I find that nobody really ever tells you what the next step is. You kind of just fall into it and you think, well, you don't really know what it takes to get the academic career. And in science, I ought to have moved around to at least different labs, different universities, gone to the States, done all those kind of things. But I was also a bit stubborn and didn't really want to do all that. So I was like, well, why should I have to? Because I know I'm good at what I do, but why do I have to move around? But because I didn't move around, I think ultimately that I didn't play the game, so I didn't move around. And that meant I probably was unlikely to get my own lab, which is what I wanted to start off with. But nobody really told me that early on. I don't know if I would have done anything different if they had, because I just didn't want to move around and move to different countries. But so anyway, after my PhD, I did this research assistant post, and I came back to University of Nottingham to do a postdoc. And this was with one of the guys who vivaed me for my PhD at Nottingham. So again, I kind of fell into it, I suppose. I don't know, it is, you use your network. So he was part of my network, so I went and postdoced in his lab. And he kept getting funding, so I think it was like a 3-year, then a 3-year, then a bit extra years postdoc. And then towards the end of the postdoc, the money was running out. So if you don't know, when it's getting worse, actually, postdoc positions are normally 2 or 3 year contracts. And once the money runs out, you have to find something else or apply with the supervisor of the lab to get more money. So there's very little stability. And I think in the olden days, it used to be that you could get permanent jobs, and that was kind of some stability to aim for. But I think even now the lectureships used to be like a stable job. I think they're all kind of temporary contracts now as well, or most of them. So at this stage, I had a daughter. My daughter, when I was just before 30. And she was just about to start school as my contract and my postdoc was ending. And I was just like, I don't want to do this anymore, because I didn't know where to send her to school, because I didn't know where I was going to be working. So I started looking for other things. And after I've been in academia since I was 18, and I was now 33. And when you think, the first thing you think about is, all I can do is prepare. That's the only skill I've got. What am I going to do? And it takes a long time to realize all the other things you've got and what you can do. So I was lucky again. not many, well, there was no like formal careers advice. You kind of very much up to what your lab does. But somebody in the university put on a bit of a careers talk, I suppose a bit like this, and somebody from our firm came and spoke at that. So I spoke to him. It sounded like something I'd be really interested in, and I applied, and I was really lucky to get this job. I applied at the time. I was also divorced, so I was kind of tied to anywhere between Leeds and Leicester. I applied for because I didn't want to move too far away from my dad. So I ended up getting this job, and I feel, even though I was a postdoc for 8 years, I feel more like a scientist doing this job. It makes you think all the time. Whereas what I found with research towards the end, the exciting bit for me is the thinking of the experiment and the coming up with the ideas. The actual doing the lab work I found quite boring. And I got to the stage of, oh God, I've got to get up and do another 5 hours pipetting, and it's probably not going to work. So yeah, I'm glad I left the lab. So I trained as a patent attorney, left, that was when I was 33, and there were quite a few exams to qualify. So I'm qualified as a UK patent attorney and a European patent attorney, which is what most people will qualify as in the UK. And during this time, I also had another kid, and he's 5.5 now. So if you do look into this as a job, you'll see that the exams, everyone says the exams are really hard and they're like the hardest professional exams, but don't let that put you off, because they are just exams. And I did them when I was either pregnant, or I remember taking him when he was about 4 months old to like the exam venues and things, and just you just do it because you have to. So don't let the thought of the exams put you off. So this is just to show, so all the people on this slide, all of us, we all did the same degrees at the same time. So I did biochemistry and genetics, and then some of these did just genetics, I think. So we're all from Nottingham, all did the same degree, but we've all gone on to do very different things. So one of them is a head of science at a secondary school. I'm a patent attorney. Joelle's a research fellow at Nottingham. Trish is a lecturer at the Open University. Louise is a professor at Leicester. Lynn went off to sell diamonds and is now a photographer, which is the odd one. And then Parry, he's an innovation consultant. So I think whatever degree you're doing, there's so many different things you can do with it. So don't think you've got to do a certain thing. And even now, I'm 42 nearly, and I'm still coming across careers that I didn't know existed. Like I spoke to somebody, he describes himself as a deal broker, and he works with startups and he does the market research for them. So he's really in depth in the science, trying to find out who needs their product, if there's a need for their product. So again, that's another kind of science job I've only just come across that I think would be quite interesting. Yeah, so you don't need to plan your whole life out now. Like I said, I've done quite a lot of these careers talks, and sometimes it's with other people, and we all have ended up where we are without any grand master plan. You do one thing and it leads to something else. I think the main thing is just put yourself in positions where things can happen. Like say yes to things, even if it's outside your comfort zone. When I was at university, my first day, I was so scared of speaking to people. I didn't come out of my room for ages. And the thought back then that I would now be talking to all sorts of people all over the place and doing this job, I would never think that I could do it. So don't let how you feel about yourself now stop you aspiring to be certain things, is what I would tell myself back then now, if I could. So now I'll just talk a bit about intellectual property. So IP basically means anything that you've created. So it can be an invention, it can be some art, it can be a novel, it can be a picture, anything. And each of these different types of creations have got different IP rights. So you've got copyright, you've got design rights, which protect the shape and appearance of certain things. You've got your trademarks, which are very important, especially in some sectors if you're very customer facing. But I'm a patent attorney, so patents, as I'm sure you all know, protect inventions. So it's got to be something new, and it's got to be something inventive. So a lot of people ask how I deal with, or how I see the science part of my job and the law part of my job. But I don't see them as two separate things, if you know what I mean. To me, it's all science. but it's in the context of a framework. So like I just said, an invention's got to be new and inventive. So what is the legal definition of new? And then is the science new? If that makes sense. So it's all looking at the science, but it's in this like legal framework of particular definitions. So a patent gives you the right to stop other people doing what falls within your patent. So this is an important thing, that especially if you're thinking about setting up your own company or working in IP, most of the rights are, they call negative rights. So they allow you to stop people doing something, but it doesn't automatically give you a right to do it yourself. So I might have a patent to do a certain thing, so I can stop people doing that. But somebody else might have got a patent that's kind of above and covers over mine. So if we think of like medical use things, I might have got, say I invented paracetamol, I've got a patent to use paracetamol in any medicine, any medical use, which you can get if it's a new compound. But then somebody else might find, oh, actually paracetamol is really good for treating cancer. So that discovery is new and inventive. They can get a patent themselves to paracetamol for treating cancer. But because I've got a patent that sits above that, saying I can stop anyone using paracetamol in medicine, they haven't got, and we call it freedom to operate. They would have to take a license from me. So freedom to operate and the ability to do what you want to do is different from whether you can get a patent to your invention. And patents can be traded and treated as property, so you can sell them, assign them, license them. So like I said earlier, your invention has got to be new and it's got to be inventive. So to be new can't have already been published in the prior art. So prior art is a term that we use to refer to anything that's been made public before you file your patent application. So for academics, quite often that's their own publications. And even though when we're working with universities and we're working with an academic inventor and we say, tell us anything that's relevant, quite often they don't think to tell us about their own publications. And they're normally the closest thing because it's just a follow-on. So always be aware of your own publications. Prior art and a public disclosure can include things like conference abstracts, poster abstracts, talking at a conference, even speaking to somebody just down the pub is a public disclosure. The difference there is somebody's going to have to prove it happened. Whereas if you've presented a poster at a conference, it's on the internet, isn't it? They publish the abstract, so a patent examiner will find it. So once you file a patent application, a patent examiner, say it's the UK or Europe or the US, they will look at your application to work out if it's new or inventive for these two main things. So the examiner will look for the prior art, they'll look at your invention and say, oh, it's not new because blah, blah, blah. And then our job is to say, oh, well, it is new because blah, blah, blah. So that's the arguing of the science, and that's the bit I really like. Because quite often what the examiner is saying is just a complete load of nonsense. They've not understood the science, and that makes it quite easy to throw it back at them. So we've got to say it's new, and to be new, it's got to just have, it can be just the tiniest difference. So I remember when I was in the lab, when I did think about commercializing anything, I would think, oh, somebody's probably done this before. This kind of general method, somebody's probably done it before, so it's too late. But really, for somebody to have done something before, it's got to have been identical. So say you've got a new method and it involves a weird temperature. It's exactly the same as some other method, but you change the temperature in a way that you wouldn't normally do. That is new. And if that temperature has an effect, then it's also inventive. So I think one thing, if you go into research, kind of take a step back. If something's obvious to you, it's probably not obvious to what we call the skilled person, which I'll get onto later. So it's got to be new, it's got to be inventive, so it's not obvious. And then the other two are more, well, industrial applicability is kind of pretty much everything is. But the sufficiency and support, that kind of comes down to what data you've got to support. You can't really just read a few journal articles and write up I'm going to protect this invention. You've got to have done some experimental work to show it. And then there are just various things that you can't protect. So although a lot of what we do is a discovery, there's a technical thing there. So you're not just protecting the discovery, protecting the technical effect of that. So artistic works, like we said, they're protected by things like copyright. Business methods and things, they're protectable in the US, but not in Europe. So there's quite a lot of difference in different territories between what you can and can't get patents for. And there are certain biotech inventions that we can't get patents to, such as like modifying human germ cells. That's kind of against like some ethical concerns. So like I said earlier, novelty, it's got to be even just one difference. So if it's a single mutation in a protein, that's enough to make it new. And then when we're looking at inventive step, we're looking at it with respect to what we call this skilled person. So if you're doing research and you're doing a Ph.D. or your master's, and your job is to think creatively and try and come up with clever stuff, you're probably not the skilled person. You're probably more than the skilled person. So if you've come up with an idea or a discovery, you need to take a step back and think, would somebody who is paid just to kind of follow instructions have followed instructions and come to your invention? That's what we look for when we're assessing inventive step. So if the skilled person, or this guy, was reading this document that the examiners found, would they naturally go and modify it and arrive at your invention? If there are arguments that no, they wouldn't, then you've got inventive step. If the document said, oh yes, it would be really good if you can do this and this, then that's kind of giving you motivation and prompting you to do it. So then it's more obvious. So that's another thing. If you do go on to publish your research in journal articles, and everybody does it, and I did it, at the end, you normally have this kind of prophetic paragraph of, oh, it'd be really useful if, I don't know, somebody could look into this more, or the potential for this effect if you combine these two things. Just don't say it, because you might want to protect that later on. And if you've already said it, then you've kind of screwed yourself over later. So sorry for people who are not science background, but these are just examples of things that could be new and inventive that you perhaps wouldn't think they were, because it's such a small difference. So a different media to grow your bacteria in, you might add something to it and it grows really well. That's new and that can be inventive. One of our clients that we work with, they're very much into the PCR-based diagnostics, and they found if you just move the position of a fluorophore on a probe, you get increased fluorescence. So that's new and inventive. Different buffers can give you different improved stabilities of a compound. Like I said before, even just a single amino acid change in a protein can be new and inventive and protectable. You might have different species, different microbial species to express your protein, your favorite protein of interest. Or you might use the same host species as people have already done, but your protein, your species has been mutated, so it secretes the protein more. So all these are kind of, if you think about it, they're quite small changes, but they can have quite a big effect, and they're definitely patentable. And then this one, the combination of drugs. So this is something that I had been going on about doing my postdoc for ages. So I'd found if I grew yeast with sublethal concentrations of two things separately, so it doesn't affect the growth at all. And then when I put them together, it was just totally dead. So you had this really good growth curve of really good growth and then dead. And I was pestering for ages, like, come on, there's got to be something in this. It's either, I don't know, if it works against mammalian cells, it could be an anti-cancer, or it could be just an antifungal for things like yeast infections. And my PI then was so resistant. And it was only because I was coming for this job, I was like, please, can we talk to the tech transfer? Just so when I come from the interview for this job, I can say, you know, I've tried to do something. So we did. And then since I left, they filed patent applications on it, and he's had loads of money and students to work on it. So I don't know if I probably could have pushed harder and probably could have gone over his head maybe around that. But if you think you've got an idea, like, pursue it and don't let people discourage you. I find a lot of the more established academics, they're not as interested because they've got their job, they've got their permanent position. Whereas it's you guys that are either going to be fighting to get that position or leaving the university and looking for something else. And if you've got a good idea, you can set up your own company. That's something that I never thought about at all. I don't know why I didn't think about it. I think things are a bit different now because there's so many small biotechs starting up all over the place, which I don't think there were so many back then. But you know, I work now with a lot of people who are leaving university and setting up their own companies on this kind of thing. So it's just another career option. So now I'll just talk about a little bit more about what I do in the job. So as a patent attorney, our main job is to get patent protection for people's inventions. So I work with a lot of universities and startups, and we also work with a lot of big companies, and we're all trying to get patents granted for their invention. So one of the reasons, I gave a talk to some postdocs not long ago, and one of the main motivations I think we all went into research, if you do go into research, is because you want to make a difference in the world. You want your research to get out there, turn into a product, cure cancer, solve climate change, whatever. And I think a lot of us think the way to do that is to publish it. We're going to try really hard and we're going to get a Nature paper, and then that's going to sort out all these problems. But the problem is, once you've published it, it becomes prior art, which is what we talked about earlier. And say you've got a therapeutic and it's going to cost millions to get it through all the stages of clinical trials. An investor, or whoever you're going to get money from, is only going to give you money if they know that once you've got your product at the end, people can't copy you. So right early on, you need to make sure your patent protection in place, even if your product is not going to get onto the market 10, 15 years away, because you need to show investors that when you have got your product on the market, people aren't going to copy you. You've got the right to stop them. And that's why we get along with the pharmaceutical companies when they're coming to the end of their patent term, which is 20 years. That's when the generics companies will start getting ready to market their products, because they can then. So one of the main reasons for me as an academic that people should think about protecting their IP is so it can be turned into a real life product. And it's not just going to sit in some crappy journal on the shelves that no one's ever going to read. You want your research to make a difference. So whatever you do, try and think about whether or not you should protect your IP before you publish it. Even if then you decide to publish it, that's fine. But as long as you've kind of made it an active decision rather than being uninformed, published it and then regret it later. So the main part of my job is to get these patents granted, and that involves us talking to inventors at the start. So it could be academics, it could be people from a large company, it could be, I don't know, anybody, especially like if you're in the what do they call them upstairs? Electronics and engineering type thing, where you do get quite a lot of lone inventors, men in sheds inventing little widgets. So you get to talk to loads of different people. I've got a client now I've just taken on from based in the Netherlands. I can't even say it, the Netherlands, and he's culturing fur in dishes, like cultured meat but fur. And he's a bit crazy, in a good way. He's got so many ideas. So we talk to these people, we draft the patent application, and if you've ever looked at a patent application, it's worded really strangely. And I remember when I first started this job thinking, what the hell is this? It doesn't make any sense. You've said the same thing 10 times, just in different ways. But now, and quite quickly, once I started this job, I understood why it is like that. So it is all there for a reason. And if you do ever try and file a patent application, just beware that all patent applications are not created equally. So if you pay for something rubbish, it could be rubbish. And you know, one of our clients, they're in antibody therapeutics, it's quite high value stuff, but they've just been acquired for, I think it's like $1.5 billion, and that was just basically for their 2 patent families. Because when you I don't know, developing a drug, you don't really necessarily have loads of valuable physical stuff. You might have a building, you might have a bit of equipment, but you haven't got much tangible that's worth a lot until you've got your drug developed at the end. So all you've got in that whole time really is your intellectual property. You've got these rights that can stop people doing your clever idea. So talk to them, draft application, file it, and then it will get examined by an examiner, and he'll say, no, it's not inventive, and they'll say, yes, it is, and they'll say, no, it's not, and they'll say, yes, it is. And normally with a patent, you start off, the overall aim is to get your patent granted as broadly as it can, because the broader it is, the more kind of scope you've got to stop people from doing things. So it's like a field, I suppose. The bigger your field, the more turf you've got to keep people out of. So the patent will normally start off really broad, and we do draft them broader than we probably think will get granted, and then we will make amendments to get to a kind of reasonable position that is new and inventive and that the examiner allows. So that's the main part. Then we do freedom to operate analyses. So like I said, the patent gives you the right to stop people, I guess, coming into your field, but you don't have the right to put your fence up where you want to put it, because somebody else might already have got a fence in that bit. So some of our clients will say, this is my technology, I want to use bacteria to treat cancer. What are other people doing, and will I infringe their patents if I do what I want to do? So that way we're kind of looking at it in a bit the reverse, really. So instead of getting something granted, we're looking at, do we fall within the scope of this patent? And they're quite interesting. So we have to give commercially focused advice, which I don't think all patent attorneys do. And this does come with time. I remember, so I was 33, literally lived my life in a lab. I didn't know anything about business. And I remember asking the managing partner, how do you know it? He says, it does just come with time, and it does. When you meet clients, I've made quite a lot of effort to read things, get involved in certain like investor communities and things. So you do just pick it up. Because a lot of the time people think, oh, I couldn't get a patent, so I should get a patent and get it filed. When really you need to think, because then it's not cheap. So you need to try and think, do I need this patent? Even though I could get one, is it something that I should actually do? Am I better off waiting? Or, it's like this big IP strategy. You need to really work it out. We do due diligence. So if an investor wants to invest in a certain company, they'll ask us to look at their IP portfolio. So what patents have they got? Do they actually, like I just said, do they support the business, or are they just kind of random patent filings that's wasting money? So that's quite interesting. We do, especially in biotech, it's not so much in the other technology areas, but biotech and therapeutics are quite, everybody's always fighting each other. So in Europe, particularly, once you've got a patent granted in Europe, there's this 9-month opposition period where somebody can challenge your patent and it can get totally wiped out. So this 9-month period is really useful, because after that, the patent is it exists independently in each of the European states that you go for. So say you went for the UK, France, Germany, Spain, Italy, they're all then separate patents. And if you wanted to knock them out, then you have to take the company to court in each country, which is obviously very expensive. So this 9-month period where you can knock the whole patent out in one go, a lot of people do use that. One of the less SynBio things I've worked on, it's a heart occluder device. So it's just like a braided widget that goes in one of your atriums in the heart. And there were two, so we're acting for one part, and then there's another company that makes similar, and they are always fighting and going to these oppositions, and it's quite it's interesting what people do. So also, as part of my job, I do a lot of business development, which I'm doing more as I get more senior through the company. So things like this, conferences, talking to people, all sorts of things. Licensing, that's more the IP solicitor side of things, but I've been involved in some of those discussions. But it's interesting because I can't really put a value on all these patents that we're getting to people. So seeing the discussions that companies have as to, oh yeah, you're going to give me this much, then I'm going to have all these royalties, and then you're going to give me these milestone payments, and it's like, oh, it is worth getting these patents. But yeah, to me, like I said, it's all just science, whether you're acting for investors or fighting somebody in like European court, it's all science. I think that's why I really enjoy it. So this is just some of the, so like I said, my background has everything I've done really has been in yeast, just different types of yeast, and I've been very molecular, loads of cloning, far too much cloning. But these are just some of the things that I've worked on. A lot of these are with Imperial College, because we do work with Imperial College, and they're coming up with some cool stuff. We work for LGC, which is they do a lot of PCR-based diagnostics. So trying to capture, and well, probably for Imperial actually, some of the ones trying to capture in words a PCR reaction where certain things have to be in a certain place and bind to different regions. It can take me 2 days just to draft the first claim, because you draft it and then you think, oh, somebody could challenge this word, or if you interpret it in a different way, it just doesn't make sense. So you have to be very clear with what you're doing. It can take time. So yeah, all sorts of different things. So the things that I really like about being a patent attorney is the science, really. It's the science, and it's very varied. I think some people, I think it depends where your cases end up coming from. So I trained under a partner who did quite a bit of university work. So because universities are working with lots of different academics, it's all different subject matter. It's all biotech, but it's all from different labs. So I've got a lot of that. And then I'm taking on a lot of clients in the synthetic biology space. So it's all very different. Whereas other people at our firm, they work for one or two big clients. So I've got the girl I share an office with, she works for a big, well, it's not even a big company, it's probably an SME, but they've got a lot of work on antibody therapeutics. So her work is antibodies. Like, oh God, that's so boring. But it's I think it just depends who you train under and what you want, I suppose. Because I quite like the variation. Some people probably don't like the variation. And if you so I work in private practice, whereas you can also be an in-house attorney, so you could work for GSK, in which case you're very embedded into their company, and you I guess they still have lots of different products, but you'd be very into their products, whereas I get quite a lot of variation. So like talking to the scientists, because we have to do it as part of our job. It is very creative, which is one of the things I like. Because what I liked about being in the lab was coming up with the ideas. And that's what I like about this job. When you read an examination report, you think, oh, well, he's wrong because, and then coming up with those ideas. The people, everyone at our firm's dead nice. I like doing this kind of thing, talking to people, because I know when I was in the lab, even before I left at 33, I knew nothing about IP, didn't care about it. And then after, I think 6 months later, I went back and gave a talk. It's like, this is everything you need to know. Now I know it, and you really should know it and be thinking about it. So I'm spreading the word. Glad that there's no lab work. It's a permanent job, and the pay is good compared to academia. So the things that I don't not like them, it's just less fun. So the way we make money is my time is recorded, and I have to turn my time into an invoice. And that can take quite a bit of time. And it's also, I don't know, when I see how much my time has added up for just even 2 hours, I'm like, oh my God, how can I charge somebody that? But that's what it is. It's just ridiculous. I never thought I'd be like, my charge out right now is £60 an hour, which is hilarious, but that's what it is. So when I was doing a postdoc, I'd have 5 or 6 different projects all on the go, all like in a centrifuge at the same time and all over the place, and I could move between them dead easy. I knew exactly what was going on. Whereas with this job, especially early on, you have to get so in depth in one case, and then you have to get so in depth in another case that quite often I'd be working on a case in the afternoon, I'd totally forgotten what I'd done in the morning. You'd read a letter that you've written, it's like, I didn't write this, even though I only did it a few hours ago, because it's just, ugh. But now, I think once you've been here a certain amount of time and the cases keep coming back, because everything's got quite long deadlines. So an examination report will come in and it's got a 6-month deadline for a response. So when you've responded to it, it might be another year until that comes back. So it's quite, there's big gaps between things. So once you've been here or doing the job a while, you're used to the same thing coming back a bit. So it refreshes your mind, think, oh yeah, it's that one. So it's a bit better. There are the odd, difficult clients, mostly because people don't want to pay or they try and get a little discount, which is fine. But some of them, I think some of them just don't know enough about IP, which is not their fault. And I think I'm trying to work on a bit of an educational product for us at the minute, because I think we're asking our clients to make decisions that perhaps they're not capable of making, they're not informed enough to make, and we can tell them as much as we can, but so I think that's a problem. And this, I don't think this is even true anymore. For a while after I left the lab, I occasionally missed being in it, and I would have a dream where I went back to the lab and it was really great, and then all of a sudden I'd come to my senses in my dream. I'm like, oh God, what did you do that for? So I don't miss being in the lab anymore at all. So I was trying to think of this, because I've got one trainee who I've had now for 2 years, and I've just taken on another one in London. So I'm just trying to think of the things that I think you need to do this job. And to me, one of the so I know we've got people from the Law Society here. So to be a patent attorney, you don't need a law degree or a law conversion. You need to have a science degree. So to sit the European exams, you have to have a science degree. You don't come at this from the law side at all. You come at it very much from the science. So you need the science degree, science background. You need to be motivated, because a lot of it is kind of self-driven. We work all together in a team, but what you're doing at each point is kind of on your own, really. It's very creative, and I think that's my favorite bit about it. You have to be good at project and time management, which if you've done any research or that kind of stuff, you will be. So just dig that up on your CVs. Because like I said, I can be working on 15 different things at once, and you have to manage all the deadlines, and because they are proper hard deadlines, and if we miss a deadline, people lose their patent, which can be millions of, it's hard to put, like I said, it's hard to put a figure on it, but yeah, we don't want to screw things up for people. But especially early on, you are not responsible for those deadlines. You're responsible for your own deadlines. Like if I tell my trainee, I need this back in a couple of weeks, it's not going to like ruin anything if he doesn't get it back to me a couple of weeks, but he needs to learn how to manage his deadlines. You need to enjoy science, because it is all sciencey. And you have to be able to read scientific information and pick out the bits. It's not that you have to understand the entirety of science, because I don't. Every time I pick up an antibody case, I have to refresh my mind of what all the different bits and bobs of antibodies are. But you have to have the ability to do that, I think. Look at things from different angles. So if I'm drafting a claim for a patent, and I want it to cover, in my head I want it to cover this, I have to then look at it from another angle and say, well, if I was trying to challenge this, what would I say? Would I say it doesn't make sense? Or would I say this term's so broad, it's actually capturing something in the prior art, so it's not novel? So there's a lot of things you need to think about. Talk about complicated things to people of different abilities, really. And writing, I know there are some people in our firm who say you have to write succinctly, but definitely don't. But the person I was trained with is very much brief, no fancy words, like you have to crush the word elucidate out of yourself, because everybody in academia elucidates everything, and we don't elucidate as a patent attorney. So yeah, just normal, plain language. So if you are wanting to apply for a patent attorney position, to try and demonstrate all these things in your cover letter. Try and get something that shows you've had an interest in IP, because when I took on Rob, we'd had about 200 CVs, and everybody's either got a degree or a master's or a PhD, and you need something to make yourself stand out if you can, and it's hard to know what that is until you see it. Definitely look at the company that you're applying to and tailor your letter, because we've had some that, they've sent us letters with somebody else's company name in it and things like that, which is not, it's going to go straight in the bin. But don't be discouraged. If you want to go for it, then go for it. So this is just why I think you should think about IP, whatever you're going to end up doing. So if you're going to go into research, just make sure you think about it. It's in the back of your mind. Should I think about protecting this and go and talk to the tech transfer office? If I don't and I publish it, that's great. But the chances then of it being turned into a product or having an impact in the real world is lower. Yeah, so like the second point, if you do just publish it, it means nobody's going to pick it up, probably, potentially. And then because an application is published, that information does get out there, and it is then available for the people to work on and improve as well. And there are some arguments as to, if you're being funded by public money, do you have a duty to kind of try and get some money from your research back into university? I'm expecting, like, after COVID and everyone complaining about people profiting from publicly funded research, I feel like we're going to see universities even more pushed to commercialise their research, to bring some of that money back in. Funding bodies, if you go into academia, they want to see that you've got impact from your research. They don't, yeah, fine, you publish it in a journal, but what actual real world impact is it having? And I think most universities have a system where if you're an inventor on a patent, so we haven't talked about ownership, but most of the time, if you invent something at the university, it will belong to the university unless you're a student. So you invent it, the university probably owns it, but they have kind of scheme where if they license it out, you and your lab will get some money back. So it's a way of bringing back money into the lab. And like I said before, it could be a potential spin out for you, your own career development. Because one thing I realized, nobody's going to give a shit about your career for you. You've got to do it yourself, which I never did. I just happily blundered from one thing to another, and it's all turned out well. So perhaps that's all you need to just like bounce around and do whatever feels right at the time. But definitely this last couple of years, I'd say get on LinkedIn, build up your network, which I didn't do, and now I'm really glad I did. I wish I'd done it earlier. There's so many people out there who just want to chat. If you want to talk to somebody, just ask people to talk, because most people are nice, they're not idiots, and they're happy to chat to you and give you some advice, or I don't know. That's something I need to do a bit more. I've had a lot of people coming to me saying, oh, can you have a chat? I'm like, yeah, I haven't found myself approaching people yet, so I need to do that a bit more. So yeah, just take charge of it and like stick up yourself. Like if you're going to research and your PI squashes you down, time to get lost. And I think that's all I had. So thank you.